Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. After Carmelo Anthony was convicted and sentenced, his new defense team went looking for the case file to prepare a motion for a new trial. According to their own filing, I get it. Not because it was lost, but because the judge had it in his chambers, sealed by an oral order with no written order, no hearing, and no findings. Today, I'm breaking down whether that's actually legal. I'm Cassandra, your favorite paralegal, and this is Legal Doc Talk. Quick foundational point because it matters a lot. In Texas, court records don't belong to the judge personally. They belong in the custody of the district clerk. This is not a technicality, it's statutory. As you see on your screen, I have pulled up Government Code Section 51.303. Duties and powers. You can pause and read this for yourself. And as you can see, it shows the Texas Constitution and statutes. Okay? So this code and the local government code make the clerk the official custodian of the court records. The whole point is that anyone, a party, their attorney, a member of the public can go to the clerk's office and access the public file. So when a judge personally holds an entire case file in his own chambers instead of the clerk's office, that's already outside the normal structure. That's before we even get to whether it was properly sealed. Here's the timeline. According to the filing, Carmelo Anthony was sentenced on June 9th. The next day, June 10th, his trial counsel withdrew and the court appointed a new appellate counsel. That counsel was then replaced. Present counsel weren't substituted in until June 23rd. Three different sets of lawyers cycling through, all while a 30-day statutory deadline to file a motion for a new trial was running. During all of that, according to the motion, the reporter's record of the trial had not been transcribed at all. Counsel contacted the official court reporter and was told nothing had been done. And the pleadings and the case file weren't even in the district clerk's public record. They were sitting in the judge's chambers. Then at a conference on June 29th, the court told the parties directly the entire court file had been sealed by oral order. Counsel could inspect it, but only if he agreed in advance not to disclose anything he saw inside of that. Counsel then said that he could not ethically commit to that without knowing what was even in the case file. So the file stayed in the chambers, inaccessible. So can a judge seal an entire case file like that? Absolutely not. Not under Texas law, not with what we are describing here. Sealing court records is governed by Rule 76A of the Rules of Civil Procedure and the Open Courts Guarantee in Article 1, Section 13 of the Texas Constitution. Here, definitely pause if you want to go ahead and read that. You know what? I'm going to read it for you. Standard for sealing court records. Court records may not be removed from the court files except as permitted by statute or rule. No court order or opinion issued in the adjudication of a case may be sealed. Other court records, as defined in this rule, are presumed to be open to the general public and may be sealed upon showing of all of the following: a specific, serious, and substantial interest, whether clearly outweighs the presumption of openness, any probable adverse effect that sealing would have upon the general public, health, and safety, no less restrictive means than sealing records with adequately and effectively protect the specific interests asserted. Then going over to the Article 1, Section 13. Let me just make sure. Yep, Section 13. It says excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishment inflicted. All courts shall be open, and every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law. So the framework requires, as you can see, a real process before the records get sealed. One, public notice that sealing is being sought. I'm sorry. Two, an open hearing where anyone can show up and object. Three, specific written findings showing a genuine, serious interest that outweighs the strong presumption that court records stay open and that there's no less restrictive way to protect that interest. What's I'm describing today here checks none of these boxes. No written order, no public notice, no open hearing, no findings at all. Just an oral statement at a conference that the whole file had been sealed. And here's the phrase from the motion that I think nails exactly why that's such a problem. An order sealing order can't even talk. An oral sealing order with no findings is sealing in its less revealable form. Think about what that means practically. There's no written order to appeal. There are no findings to challenge on the merits. There's not even a clear record that a sealing decision was ever formally made. It's about as close as you can get to unaccountable. This is where it stops being just a procedural irregularity and causes real harm, according to the motion. This wasn't sealed during trial as some kind of security measure. It happened after conviction and sentencing, during the exact window when brand new counsel, who never worked this case before, had to figure out the grounds existed for a new trial under a hard deadline without the case file and without the transcript. Just think how hard that is. You don't have the case file, but you have a 30-day window to file a motion for a new trial, and you don't even know what the grounds are because you don't have the file. The motion makes the connection explicit. Remember, the motion in limine we covered before, the one that was hand delivered and never hit the public docket. The motion argues that anyone checking the public record during this period would have seen nothing and reasonably concluded no substantive pretrial fights had ever happened. The, the sequestration, of the file is exactly what prevented anyone from testing and that false impression in time. Why are we hiding the file? That is the biggest thing. Everybody can say what they want. Um, People are still hollering old stuff. What's done is done. We are at this point right now. What is the sole purpose of holding this file in your chambers? What is the purpose that the transcript has not been transcribed? I have never, ever seen this in my life that I've been working as a paralegal in the legal field. I've never witnessed anything like this. Now, this ties directly into the broader public trial argument we've been covering. The motion's position is that public trial doesn't just mean who's allowed to sit in the gallery, it means the record of what happened has to be accessible too. A courtroom that's technically open, sitting on the top of a record that's sealed in a judge's private office, isn't meaningful open at all. The motion frames this as one more piece of consistent pattern, not an isolated slip up, but a structural restriction on public access that reached the courtroom, the pretrial litigation, and now the file itself. Standard caveat, but an important one here specifically. This account of the sealing, the oral order, the non disclosure condition, all of it comes entirely from the defense own motion. The state hasn't responded yet, and there may be context or justification the court would offer that isn't captured in its filing. But based on what's actually in the record right now, it's see what legitimate basis exists for sealing an entire file orally with no notice, no hearing, no findings, especially after the trial had already been concluded. So I'll be watching to see whether the court unseals this file or whether we get an actual written order explaining the basis for it. So make sure that you are following me so you can catch the update. And drop a comment below if you want me to cover more of the 76 rule of Texas rule of procedure, civil procedure in more depth, because it's a very genuinely important rule that I know people have not heard about, but it's important in this case because you can't keep the file in your chambers. An oral seal is not going to cut it. I'm Cassandra, aka your favorite paralegal, and this has been Legal Doc Talk. This video summarizes allegations made in defendant's motion for the new trial in State versus Carmelo Anthony regarding the custody and sealing of the case file. These are the defense's own characterizations. The state has not yet responded, and no court has ruled on the validity of the sealing described. This video is for legal education purposes only and does not constitute legal advice. All individuals are presumed innocent unless and until proven guilty. Once again, I'm Cassandra, aka your favorite paralegal, and this has been Legal Doc Talk. Bye.